My first 4 videos for my revamped website were statements of purpose. I invite you to watch them. It takes a total of 7 minutes. My statement to potential clients, to colleagues, to adversaries, and to those in authority. Some of the ideas that I have about my approach to the practice of law. This is going to be a substantive video, perhaps as long as 10 minutes, in which I discuss some ideas that fit within a broad umbrella called Future of the Law. The Future of the Law fits within an even broader umbrella of the subject of our era of information and accelerating change. If lawyers are to remain relevant, we have to figure out how to provide services and products for a modern world. There are at least a dozen general categories. I'm going to focus on something I call, and others call, unbundling of legal services. I'll be talking about unbundling of legal services to self-represented people who do not think they can afford or who are stubborn and simply don't want to hire a lawyer in their family law matter, to people who have disputes that they may or may not want to litigate, but also another package of services fitting under the term legal checkup, in which a lawsuit's not going to be required, and it falls more under the category of preventive law. And I'll talk about that in a few minutes. Finally, there are mediation services in which a good mediator can meet probably also with self-represented parties, although most of my mediations are with represented parties. I represent my client. The other side has a lawyer, but there are times when a couple could come to a mediator. In the past, the rule was one lawyer cannot represent 2 parties, and it was a very rigid rule, and lawyers could get into big trouble if they filed a petition for one and provided the form for an answer to the other. But a mediator doesn't represent either side and does not control the decisions of either side. An ethical mediator will educate but will not unduly pressure, and will do everything in that mediator's power to make sure that there's not a disproportion of power or control in the mediation. The model that we're used to is charge a retainer with a small non-refundable consultation component to it, and charge at an hourly rate, charge enough that if the case goes relatively smoothly, even if it goes into a fairly lengthy mediation, that the retainer will pretty much cover it, perhaps put a little buffer in there, a discount, and if it goes over that retainer, I usually charge a lesser hourly rate. And I'm available, and just call me and I will quote that retainer, and the conventional model is by far better than doing it piecemeal. But what about the person that simply cannot or will not retain an attorney? I believe there's something we can do for them also. If an attorney becomes record counsel, then they are bound to put their signature on everything that gets filed. They have a fiduciary obligation to the client, and they must follow strict rules relative to withdrawing from the case. But if an attorney is hired as a consultant, and I saw an interesting term during we're on our vacation right now in Connecticut. I saw a sign of a family law lawyer where they call themselves a divorce coach, and they have a certain kind of collaborative divorce that has not made it to West Virginia yet. What do we provide for an unbundled service, and how much does it cost? I have 3 products that are simply $500. It's not based strictly on an hourly rate, so I might only spend an hour with you, but I certainly expect to provide you at least $1,000 worth of value. But I might spend a couple hours, maybe even 3, in order to let you understand what you're facing. In a family law case, you probably need to see the forms that are filled out in a typical matter, such as the financial affidavit, Bureau of Child Support Enforcement application, the caretaking functions worksheets that are important if you have younger children in order to determine how you had apportioned the parenting for the year and the 2 years before you separated, and other forms that must be filled out that you could get by walking down and paying the money for the do-it-yourself package. I believe that the powers that be that issued those do-it-yourself packages meant well, but I believe that it's resulted in chaos, and I see every week somebody who has been severely disadvantaged by not knowing how to proceed. And getting rulings at preliminary stages, maybe even getting a final ruling that is devastating to them simply because they did not know how to present their case. So unbundling has a component of it called ghostwriting, where a good, efficient consultant can draft some paperwork for the person to put their own signature on. One word of warning, about half the people who think they're going to just purchase the unbundled service, once they realize what's involved and they have the various stages explained, they decide they just need to have an attorney. And if I've established a good rapport with that person, believe that they are reliable, we can move to a different model that does not require a substantial lump sum payment. We also do something called a legal checkup. This works real well for people who are approaching their retirement, people who have blended families where maybe they have an adoptive child of their own that maybe the husband adopted, or maybe they had a child of their own, but maybe they each have one or two prior to their relationship with one another, and they see potential chaos in the heirship and the medical power of attorney issues, the general power of attorneys, and their wills. And we can cover a lot of that. Now, if we can't fit it within the $500 flat fee, if they need services more than that, it's possible to extend the unbundled part of this based on additional quoted fees, but it's also possible in a matter that requires a lawsuit for me to become your representative and move to the more conventional model. Finally, there is mediation for unrepresented people, where the mediator can rough draft or rough out a parenting plan, a property settlement agreement, even a final order subject to the approval of the court. I have a product that you can find just by typing in the phrase digging down in my blog, and I do want to have a few seconds here at the end to talk about my blog. It's got a set of forms that you can use to organize the facts in your case. I believe once you really get into the 8-page digging down article and see how important it is to gather the people and the documents, the places, the events, and the organizations that make up your case, you're probably going to realize that that's something that takes law school and some experience to put together. But we do try to help put you to put yourself in a position that you're not going to get hurt too badly, and that the judge is going to understand your point of view. And if that's all you can afford, I believe you should have that and not be thrown in to the water, unable to swim, and possibly drown. This is a bit of a life preserver to help you avoid that. It has to be very carefully conscribed. In other words, the contract has to be clear. And the key is specificity on what's being purchased and offered. I'll let you have copies of the statutes, the family court rules, the limiting factor rules. If there's been abuse or neglect of some type, I'll show you West Virginia Supreme Court cases, Mr. and Mrs. Molnar, a landmark case on when permanent alimony is appropriate, cases of my own. I've got an extensive history of going to the Supreme Court when I feel my clients don't get the right ruling, and about half the time we've been able to succeed and obtain reversals. I can share that. I do want to point out that 46 years of experience, 41 here in West Virginia, and an innovative approach and a 1,400-page blog, fully searchable, are the kind of things that not everybody has and not everybody is interested in. So if you're going to follow this route with an attorney, I see that. Thank you. If you're going to my director says it's time to wind this up, folks. So if you're going to have an attorney that is experienced, willing to teach you, willing to be patient with you, and willing to work with you. I hope I can hear from some of you, and I hope we can be of service. Thanks.